Okay,
Oh, there you
good.
go.
We're doing it. All right, so this presentation explains the basics of patent litigation, including the minimum requirements for filing a patent lawsuit, typical stages and timeline of litigation, common pitfalls that inventors and patent holders should avoid. It's designed to help inventors understand the legal and practical aspects of enforcing the patent rights, even if they hope never to become involved in litigation. The presenter Kirby Drake is an experienced intellectual property attorney specializing in patents, trademarks, trade secrets, and copyrights, and has held leadership roles in both the State Bar of Texas IP section and the National Association of Patent Practitioners. Kirby has indicated that if you have questions while she's doing a presentation, just interrupt. It's a very small group, and we have, less than 9 participants because I'm logged in twice. So other than that, Kirby, take it away.
Great. Thanks. Yeah, no, we can definitely make this make this informal and I'm happy to answer questions as we go along but leaving plenty of time at the end so that we can have more discussion, particularly if you've had experiences with litigation or things you're curious about, then I'm always happy to talk about that. So what this presentation today, I'm going to highlight, as the summary said, just some different things that I think are helpful for inventors to know. If you're ever thinking that you may be getting into the litigation process, or if you're just seeing things out there as to other patents and just curious about what particular terms mean, or what stage they're in a lawsuit, then hopefully this will give you some of that information. And the other thing to keep in mind is this is going to be at a high level, and there will be some places where I'll point out throughout the presentation that it may be very dependent on, which, I was going to say which state you're in, but it's all in the federal system. It's just a matter of, where you've actually filed your lawsuit, because there are some different district courts in different states that have specific rules as to how they handle patent litigation, or like in the case of Delaware, Delaware and New Jersey see a lot of the pharmaceutical patent litigation, and they have specific rules that even relate to generic pharmaceutical patent litigation, which would be referred to. Sometimes you'll see it referred to as ANDA litigation. So I'll try to point out some of those things there, but I've tried to make this presentation applicable for most of the things that would be relevant, no matter which court we're talking about. So let's see, go here. Yeah. So where we're going to look at today is just a couple of things. So first is just the minimum filing requirements. What do you have to have if you're going to actually put a case in front of the court? And I think this is also helpful to, if even if you're not actually going to get into litigation, but you're thinking that you want to, you identify that somebody may be infringing your patent, and you're considering, well, can we send them a letter? Can we have communications to, show them why we think they're infringing, and maybe try to resolve something outside of litigation? I think all of these things will be helpful to you for thinking about just basically the process that you're going to need to go through if you're, essentially accusing someone of infringing a patent. Then we're going to talk about kind of the typical litigation timeline, and giving you some ideas of, once you file a complaint in a patent infringement lawsuit, what happens in the various stages, and then, up through, after the judge or the jury decides the case, and then possibly, you doing an appeal or the other side doing an appeal. And then finally, we'll look at some of the pitfalls that are most common in patent litigation, and some of the things that are common and can often be very costly, when you get into patent litigation. So hopefully things that you'd avoid if you're if you're getting into these kinds of cases. So I always like to start as, I don't I'm not the type of attorney that is thinking of patent litigation as the first step that we're considering. I typically think of it as, we'd like to think of it as a last resort. Hopefully you can work everything out amicably with potential infringers or potential licensees without needing to get into patent litigation. But even if you've been fortunate in those respects where you've not had to get into litigation, I think it's still important for you to understand it as a patent holder or potential patent holder. If you ever have to think about going down that route. So very very key is that it can be very expensive, and I mean there are ways in these days where there are you know companies that we would consider to be we would call litigation funders that can help you to subsidize for an exchange of any recovery that you have. But even then, if you're trying to look for a law firm to take on your case, there are still some law firms that will do patent infringement litigation on contingency or on a partial contingency, so that you don't have to pay all the costs. But but in those cases you're going to have to demonstrate a high likelihood of success, and they're not going to just take any case because of the expense that can go into it. And you think of, most often people are thinking of the attorney time and the attorney's fees that are involved with it, and certainly those can be costly. But probably one of the most costly parts of patent litigation really is when it comes to identifying, hiring, and getting experts to do expert reports in these cases. That can be a very expensive part of the process, and so it's necessary, but it's quite often it's a hard cost that you really can't avoid. Also, patent litigation can be quite slow, and a lot of this is dependent on the the state and the district court within that state that you're filing your case in. I've said on here it can take 18 to 36 months. There are some courts where it may take even longer than that, and then if you're factoring in having to do an appeal after there's a final decision from the judge or from the jury, as the case may be, then with the appeals, it could take a lot longer than that. Can be very high stakes. So as inventors and putting your patent into patent litigation, you are putting your patent at risk, because in almost every case, the defendants that are accused of infringing your patent are going to try to find a way to allege that your patent should be invalidated. And if that happens, then, as I said here, it doesn't just end the case. It can wipe out the patent altogether, because if they find that your patent never should have been granted in the first place, and that could be a decision made by a jury, then then you won't be able to enforce that patent further or really get any additional value from that patent. So there is a lot of risk there, and so you really want to make sure that you're making good decisions when you're potentially going into patent litigation, and even once you're in the litigation, it's it's beyond the question of whether you sue. Once you've made a decision to sue, then if there are settlement opportunities to try to resolve the case before you get to a final decision by the judge or the jury, then you may have to make some decisions there, perhaps even possibly taking less money, just because of the the high stakes and the potential for loss that can take place. So yeah, Brian, you have a question or
Yeah,
comment?
my question is, whether let's say you're in litigation, or you're thinking of going to litigation, or even you've lost,
Mm-hmm.
what is the likelihood that another licensor might be interested in your product then, because it's a tenuous thing, and do they tend to wait and say, well, I'm going to wait the 18 months and see, or do I license, or I
Mhm.
infringe? Yeah.
Mhm. Yeah, I mean, I think a lot of that is going to be very dependent on, on what, who that entity is, and kind of what their experience is with, with patents or with the litigation. I've found that in my time is, dealing with the litigation, or dealing with, with patent holders that are trying to run a licensing program, but they've been, brought it, they've gotten to the point where they've had to file a lawsuit. Then, typically you don't find that a lot of other entities are going to be, you know kind of running to the table to, to try to license it while the lawsuit is out there. They're probably going to be, more in a wait and see, kind of mode on that. And, mostly just to see, particularly if you have to go the distance in the litigation, and, and the patent was invalidated, then there's nothing, there remains nothing, there would not be anything to license in that case. And so they're risking. But on the other hand, when, especially as a patent holder, if you're sending out, letters, or you're trying to engage in those licensing discussions while a lawsuit is going on related to the patent, you also, as those, potential licensees, they're also running a risk that, like, they really have to take it seriously. I mean, they may say that, they need to defer whether to ultimately agree to a license until they see what happens in the lawsuit. But at the same time, they're going to have to be doing all of that, non-infringement assessment, invalidity assessment, essentially cost benefit analysis on it, because, because they find that, if they just blow it off and think, well, I'll just wait and see what happens with this lawsuit, and they're already on notice of the patent, then, not only have the potential damages accumulated, they could also be, seen as willfully infringing, because they were put on notice, and they didn't take any steps to change their behavior, once they were put on notice, if there's eventually a finding of infringement. So
Yeah, thank you. So just the follow-up question, if
yeah.
as the patent holder, am I legally obligated to mention that I think there's somebody infringing our patent when I'm trying to license it to another organization?
No, you don't have to, have to, tell them. I mean, I think it depends on what, kind of what the circumstances are. I mean, I think that if you had, it'd probably be more the case if you were dealing with, a potential, sale or acquisition of the patent, where that's going to come up in your due diligence related to, like, yeah, they're probably going to ask, like, do you think that, somebody's infringing this, or are you concerned about, those things, because eventually um, those, could be issues that the acquirer, may want to be aware of, and decide, how they're going to behave. Where it could come up, in a licensing context, and this would be a very unique situation, would just be if you're, if you're working towards, trying to get a licensee that is going to be your exclusive licensee. You might have, may not rise to the level of an obligation to tell them about, potential infringers, but there is something under the law where an exclusive licensee may have the right to, in some cases, to sue for infringement of a patent. And so, so you're kind of, essentially you're kind of bringing them in as a partner, even though it's, a licensed situation. So, you'd probably be, wanting to disclose more of that information to them, because they'd probably be paying a premium to be an exclusive licensee.
Thank you, because it sounds like that's actually may not be a bad strategy
Yeah,
for
no,
for
it's
pursuing somebody that's infringing, getting somebody who would license the patent and then go sue them for you.
Yeah. Yeah. I mean, well, and there's also sometimes where, you know, kind of in, you know, especially if you have potentially, you know, multiple infringers, then, you know, a lot of a lot of the strategy discussions when it comes to, you know, patent litigation is, you know, well, are you going to sue all those, you know, all those uh infringers at the same time? Are you suing them? You know, do you need to, you know, try to see if you can get, you know, a quick resolution of one case and then maybe build up to like the bigger infringers? You know, there's lots of different ways that you know, that it can be handled. And so, you know, so you may, you know, find some situation like that where you know, you enter into, you know, some sort of arrangement where, you know, where it may be with a, you know, with a bigger partner that may have the may have the purse strings to, you know, to be able to, you know, to fund that litigation maybe more so than you can.
Great, thank you.
Of course, absolutely. So now let's go into a little bit more about the filing requirements. So kind of mentioned, and you know, I think your question was good. So you know, there's always the question of, well, who can file a patent infringement lawsuit, and so, you know, so on the first line, you know, this is what's most, you know, most typical is that, you know, it could be, you know, it could be an individual inventor or set of inventors. It could be, you know, the company that you know, that has, you know, has had the rights assigned to them, you know, of that invention. You know, so that could be the, you know, the patentee or the assignee. You know, it could be, you know, it could be that you have, you know, a set of inventors and they've you know, they've created an entity, you know, particularly, you know, that's going to, you know, have the patent assigned to it that you know, gives them the right to sue. And so that's the, you know, all of those different situations are our most typical cases. But as I mentioned in answering that question, you know, there is a potential for an exclusive licensee. You know, if the license agreement is set up in this in sort of certain way, then they, you know, they generally, you know, would be considered to have, you know, some sort of ownership rights. You know, so they, you know, they can sometimes sue on their own, but, you know, quite often it's that, you know, they would sue along with the, you know, along with the patent holder. So you might have two plaintiffs in a particular lawsuit if there's an exclusive licensee involved. But then if you, you know, if you're a non-exclusive licensee, you generally don't have the standing. So, you know, so you're just getting the, you know, the right to be able to, you know, to use the patent without, you know, without infringing, but you haven't been assigned any you know, enforceable property right that allows you to, you know, to bring a claim for patent infringement. So we're not going to really have, you know, if there's non-exclusive licensees involved, then there's really not going to be you know, be an issue there for as to whether they could sue, because they generally cannot. So then another question that comes up is you know, and I've mentioned a couple of times that, you know, we have, you know, if you're doing a you know, if you have a patent infringement lawsuit, it's going to be in federal court. And so, you know, but we've got, you know, multiple federal courts in, you know, well, some states may only have, you know, a single federal district court, but like here, you know, I'm here in Texas, and we have, you know, we have four different districts, and then there's, you know, and then there's multiple judges within each district that, you know, that could handle, you know, could receive a patent infringement lawsuit. And so, you know, so typically, you know, we're looking at the federal courts, and so that's going to be your U.S. district courts. You're not going to have state law claims for patent infringement, and the other kind of down the road, if you do have to appeal, you know, you may have heard in, you know, in you know, talking about appeals, you know, if you're doing that within, you know, like Connecticut, you know, I don't remember what the, you know, what the circuit court number is, but like here in Texas, we have, you know, if you were just doing a general lawsuit, you know, federal lawsuit in Texas, then you would be appealing to the Fifth Circuit, because that's where Texas falls. But in the case of patent infringement lawsuits, all the appeals go to the federal circuit. which resides in Washington D.C. And so they're considered to be more of a, it's kind of a specialized, have specialized jurisdiction when it comes to patent cases. And most, if not all, of the judges now have some sort of technical background, so they're considered to be more uniquely positioned to be able to decide these appeals. But your federal district court judges, in most cases, are not going to have any technical background that's specific to the patents. They're going to be hearing cases on lots of different topics, and patents just end up being one of them. But as to when you're deciding whether which court you go into, we have to look at where the defendant resides. So you'd be looking at their state of incorporation, if it's a corporation, and then but it also could be where they've committed acts of infringement and maintain a regular established place of business. So so if you have very large corporations that they may be incorporated in a particular place, but they have offices in lots of different states, and that could be considered regular established places of business. Then if acts of infringement are taking place in that state, then that may give you more potential places where you could sue. This is an issue that comes up a lot in patent litigation cases. We had, and we were here in Texas, we saw a lot of these challenges, and there's been some court decisions, including cases up to the Supreme Court, that have evaluated what the proper venues are for patent infringement cases, because there were one time there was the Eastern District of Texas was considered to be a very popular patent venue and place to file your patent cases, because they had developed specific rules around patent infringement cases, how they could be handled. Cases moved faster here. The judges actually wanted to see these cases, and at one time it was considered to be a very plaintiff-friendly venue. And so now we since we had cases like TC Heartland over the years, then the courts have started to enforce the venue provisions a little bit harder, and so you do see a lot of, if you just try to pick a venue that you think is favorable to you without considering things around the defendant that's at issue, then you may end up having to deal with a venue challenge, which would not be ideal. So you want to keep that in mind when you're deciding where to file, and that's something that if you're working with particular attorneys, they will they may have preferences, but they should be telling you pros and cons of each one, particularly as to whether you're likely to get a challenge to the place that you decide that you're going to file the case. So then perhaps the most important aspects of a kind of moving forward with the patent litigation is thinking about, well, what do I actually have to have in a patent infringement complaint? And this is something that I have a lot of discussions with patent holders when they come to me, and they'll say, oh, I think that there's this this company that they're infringing my patent, and so so first and this kind of gives you an idea of a lot of the due diligence that we have to do, when we're evaluating whether we can even file a patent infringement complaint. So first we would assess, for the entity that's coming to me, saying that there's infringement, do they actually own or have the right, to sue for patent infringement? So ownership would be something we'd need to show. Then we want to look at the patent itself and seeing, do they have one patent that might be involved? Are there multiple patents involved? And then when you look at the claims in each patent, are there, is there just one independent claim that's infringed, or are there potentially multiple that could be at issue? But then the part that is most important, and what I think a lot of inventors they may not fully appreciate, particularly when, when they do think that someone is potentially infringing their patent, is that, we're going to have to identify the accused product and then provide a, claim by claim factual basis that ties that product or process to specific elements of the claim in the patent. And I've got an example on the next slide that we'll go through. But this is the part where, as I said, quite often people will come to me, they'll say, I have a patent and, this company is infringing my patent. And they're just thinking about it in the context of, what they've described in the patent and not necessarily what actually got issued out as a claim in the patent. And that's what we have to really look at, because we're going to have to match each of those limitations in at least one of the patent claims to what is actually contained in the product or in the process that's being accused in order for there to be infringement. And if one of those things is missing, then there's no infringement. And then finally, with notice and damages, of course, we always, want to look at, whether there is, whether you've put them on notice, put the accused infringer on notice of your patent beforehand, because that might form the basis for a willfulness claim down the road. And then we want to see, well, how much can we figure out, kind of how much money, how successful has this product been for them, and if there's any basis for injunctive relief, which would mean that they should have to stop selling the product if you're successful in your litigation. So let's look at this example, and this is just a kind of a random one that came up with. And so, as I said, you can't just say, I think that this product infringes my patent. That's not going to be sufficient in a patent infringement complaint. And so, if we have a claim here that's for a self-balancing personal mobility device, then in this case, there's three limitations or three claim elements that are listed, and we're going to have to show for if there's a particular product that is accused of infringement, then we would say, well, what part of that product is matching up to the frame having a longitudinal axis? And typically, as you see in this first example, we'd say, it's an aluminum frame running the length of the device, and it says here, as shown in the product manual, but it may be that you include a picture of that of that, or an arrow pointing to exactly what you're referring to as the frame. And then the same thing would be the case with if you needed to then show two ground engaging wheels that are mounted to the frame, then we'd want to, find where those wheels are present in a picture of the product, and, and identify that. And then same thing with a sensor. So if, in this case, if you've had to do essentially, a tear down or a breakdown of the product in order to confirm that it has that sensor, then, then you'd want to put those, those details into kind of this chart form that you need to do. And you don't in most courts, you don't necessarily have to put it in a chart form, to meet the requirements, for filing a complaint. But I think it's always critical to have done this analysis, because you're going to have to you're going to have to make some sort of showing in your complaint, even if you're going to need some additional investigation to further strengthen those claims throughout the lawsuit. You're going to have to do this because you need to be able to put the defendant on notice of essentially the basis for your infringement claim. And
I'm sorry to interrupt.
Yeah, of course.
It looks like we've got Yusuf has been raising his hand for.
Oh,
I don't know if you saw it there.
No, I did not. Yeah.
Yusuf, you have a question? Maybe I interrupted you for nothing. I'm sorry.
That's okay. No worries. Yeah. I didn't see a hand raised, but I'll keep a lookout for that. So yes, but this is where where you if you can feel pretty confident in your mapping. I mean, you always have a defendant that disagrees with how how you've read it, but if you've made a plausible reading of mapping the claim elements to the accused product features, then you may avoid a motion to dismiss your case early on in the lawsuit, which if you have to go through a motion to dismiss, then that's adding to the cost before you ever formally get into the lawsuit.
Mi-
So
mi-
oh, go ahead.
Ms. Blake,
Yes.
can you hear me?
Yes, of
Hi, thank you for taking my question.
course.
For the sake of discussion, can you provide me with a working definition of what you mean by an infringement
Yep,
on the patent holder's invention? Can you provide me with
absolutely.
a working definition so I can have a clear understanding
Sure.
of the scope of the discussion?
Absolutely. So, the very good question. Yeah, because I think that's something that we we kind of sometimes take for granted on it. But if you think about so when we think about someone getting a patent issued to them, and this is particularly in the U.S. For purposes of this discussion, when you get a U.S. patent issued, then it's protection for the invention that is has been represented in the claims of that patent. And so when and what rights you get associated with the patent is it's not giving you the right to make the product or sell the product. What it is it's giving you the right to exclude or stop others from making, using, selling, offering for sale, or importing the invention without your permission. And so when we think of infringement, it's that you've identified that there's a person or an entity out there that is, usually it's that they're making or they're selling, or sometimes importing the invention that is reflected in the claims of your patent without your permission. So when we file an patent infringement lawsuit, that's why we have to show that there's some matching between the limitations or the elements of your patent claim and what that what that accused infringer is doing, because if you don't have that matching, they're not making or using or selling your invention without your permission.
Okay, so excellent. That at least it's a good segue to my next question.
Okay.
So when an inventor initially gets an invention, correct me if I'm wrong, they file with the United States Patent and Trademark
Mm-hmm.
Office, right? So once it's approved, uh, they have ownership over
Mm-hmm.
the claims and elements of that
Mm-hmm.
invention. Am I correct so far?
Yes.
So, I mean, take for example, in the software company, like in Silicon Valley, where you have
Mm-hmm.
many people making different cell phones, and you have cell phones that in feature-wise that are very similar,
Mm-hmm.
you know. So,
Right.
I mean, how do you reconcile the features from one cell phone to another in those? I mean, because clearly there are boundaries to
Mm-hmm.
claims and
Yeah.
scopes and limitations. So I mean, then first of all, I would think that it would depend on who initially had first claim to
Mm-hmm.
the initial
Yep.
invention before someone starts creating versions of the invention to be able to compete with the actual
Mm-hmm.
first iteration of the invention itself.
Mm-hmm. No, that's it's true, and particularly, I mean, you've brought up an area that, like, we see a lot of patent infringement lawsuits that come up in telecommunications and in cell phone industry, all of those things, and it's that. And I think it is kind of a hard thing sometimes to wrap your mind around, because thinking, well, well, how can this entity claim that they've got a patent on this part, when maybe there's several other companies or patent holders that that also have rights in that area, and that's where the patent claims are so important, because because there can sometimes be very I guess very specific differences between between the patents, such that the patent office decided that all of these things could be granted, and so then but when you're evaluating whether there's potentially infringement, it's especially in that area, it's sometimes very important that you get you have to sometimes go in and take the product apart. You're having to look at whatever public information is out there. You might have an expert in in cell phones that that knows how these are working, because you're going to have to uh make that evaluation of whether that particular cell phone matches up with your with your um your patent claim, or if maybe they've done something a little bit different that that falls outside of the patent claim. So it's very it's very hard, but it's also when it comes to like cell phones, I remember I I heard some someone from a one of these manufacturers talk at one point, and they say there's potentially thousands of patents that that might be might go into a single cell phone. And so and in a lot of cases they have standards agreements and other like cross licensing and things that allow them to to have kind of common functions or common features in there. But but you as a patent holder may not be you may not have been involved in those, and so it could be that your patent falls outside of their standards or their agreements, but there still could be infringement.
Thank you. I thank you for helping me. So I guess in essence, what I'm trying to say is that
Mhm.
we, and particularly myself, as a prospective inventor, I just
Yeah.
want to know when I initially first initially submit a patent to the United States Patent and Trademark Office,
Mhm. Yeah.
that I submit it in a way that it gives me the protections,
Yeah.
it affords me the protection, so I don't have to worry on the back end and being hit with uh
Yeah.
and they have to do an infringement lawsuit.
Well, and that's where it's sometimes hard, because hard to know on the front end, and I guess Doug and I we were talking about it when we first got online. It's just that there's sometimes where we when we do an initial filing of a patent application, where we're trying to put in certain language into our description, or we're trying to include claims that are broad enough that hopefully it should make, if it issues in that way, then we're we're able to kind of get people to fall in line, and hopefully need to license your patent to be able to to do what they want to do, and all. But but sometimes we're having to we don't always have complete understanding of where the marketplace is going to go, or what people are going to do when we're filing a patent application. And so that's when sometimes we get I say almost that we get lucky that that some of the language that we may have put in there that was a little bit broader could help us later on when it comes to um, licensing, or potentially needing to file a lawsuit if it gets to that. So you definitely kind of the key thing is when you're filing a patent application, or the patent applications that become patents, that I think are strongest when it comes to potential licensing, or if you have to file lawsuits to enforce them, are going to be the ones that that cover more than just the specific embodiment that you're like, if you came up with a very specific chair, and and you said this chair is great because it's got a a special back to it that, that supports, it supports your back better. But then, but in your chair example, you always have, a particular, cushion in it, and two arms on the chair, and it's made out of a specific type of material. If you only described that in your patent application, and you get a patent that's specifically to that chair, then it's making it easy for someone else to come along, perhaps to compete with you in that marketplace, but not be infringing your patent. When they could say, well, I'll make my chair out of a different material, or I won't put arms on my chair, or I'm going to do a different type of cushion, and then they're not infringing your patent, and it's also not a patent that they need to license. So that's what I mean about trying to have language in your description, and then ultimately if you can get it with the claims that go with your patent to to cover more than just the very specific thing that you're doing, and trying to anticipate possible ways that other people that might try to enter the marketplace could try to do something a little bit different and avoid falling within the boundaries of your patent.
Excellent. Thank you so much, Ms. Drake. Thank you.
Absolutely. No, happy to do it. So, so kind of talked a little bit about these. There's, we always want to see. So marking is something that, I'm not going to spend much time on that, but if you're in business, like you're actually selling product that you think and this is you as the patent holder, if you're selling product that you say is covered by your patent, and all, then that does create an obligation for you to mark your products in a way that you're putting people on notice that your product that you're selling is covered by the patent that's at issue. And where this comes into play is that if you are actually commercializing your invention, and then you have to file a lawsuit, you can say, well, I was putting everybody on notice that my product is covered by this patent, and as a result, then you can seek damages from the accused infringer for potentially a lot larger period than just from the time when your lawsuit was filed and going forward. And so this may not be an issue, like if you're a patent holder, but you're not commercializing a product, and you're not you don't have it out there, then this would not be something that's at issue. But it is something that's important. And you can do virtual marking now, where there's some specific requirements with that, but that would be like if you're talking about a software product, or some sort of thing that's not a physical hard product that can be marked, then there's some other ways that you can mark it virtually. Notice letters, I do want to mention this because this is an area where comes up quite often for patent holders, and particularly for ones that I would say are trying to avoid the patent litigation, which I completely understand for all those reasons that we've already talked about. But but they're thinking, well, I want to put them on notice, but then I'm going to try to make a decision then about if they don't respond, or they don't want a license, or they just ignore me, then then it's still my choice whether I want to file a lawsuit or not. And while that can be true, in most cases, there is a risk when you send certain types of demand or notice letters to an accused, a potential infringer, where if they feel like that they're being threatened in your letter, and that's open to interpretation, but we'll characterize it like that. But if they feel like they're being threatened, then they could potentially have the right to file what's called a declaratory judgment action in a court that you didn't choose. So essentially, it's putting you on the defensive, even though it's your patent that would be at issue. And so what they would be doing if they decided, well, we want to file the first lawsuit rather than letting the patent holder decide whether or not they want to file a lawsuit, then they could go in and they can ask for the court to, through the lawsuit, to find that they do not infringe your patent, or to find that your patent is invalid, and that can be done, wherever they choose to file the lawsuit, and you would not have control over that. You would essentially have to still, you'd still proceed with your claims of, my patent's been infringed, but you would be kind of on the opposite side of the lawsuit, and would not have the control over, where the lawsuit's filed or how it proceeds. And so it's, I think, I point this out where I would say that, like, if you're thinking that you've got accused, people that you want to accuse of infringement, or you think, are infringing, this is the part where, a lot of inventors or a lot of companies think that they can, it's okay to just, send out their own letter, that it's harmless, that, nothing's going to happen to them, and they can still decide whether or not they can, want to file the lawsuit, and they may not work with an attorney to evaluate and send that letter. And so, but I think it's risky to do that, because, like, how I've, my years of experience, I've kind of learned where, to what extent I can say certain things in a letter and potentially not have it rise to the level of a threat, that you're going to file an infringement suit. And so I've generally been pretty successful in avoiding those declaratory judgment actions. But I have seen patent holders that have, think, they may be completely right in the assertions that they're making in a demand or in a notice letter, but they may do it in such a way that they then become surprised when a lawsuit is filed against them that they had no control over. So definitely keep that in mind, and I would definitely tell you to consult with an attorney, before you do that. Even if the initial letter is not going to come directly from the attorney, it's still helpful to talk with somebody to make sure that, that you're towing that line as well as you can. And then also on existing licenses, I mean, most cases, you're going to know whether or not you've already granted a license or something. But if if it's something that you've done some licenses, and particularly if the licenses have extended to, affiliates or subsidiaries or others that might be associated with the licensee, then, you want to make sure that you haven't already inadvertently, whether it's, direct or indirectly given somebody a license that, could defeat the claim before it starts. So that's just all part of your due diligence. Then we'll go into the, just briefly on the timeline. And so, as I said, this can last for quite a while. You have to be prepared that you're going to have to go the distance with it, because unless you're able to, you can reach a settlement at any point in time, during the lawsuit, and most patent cases, don't get all the way to trial, because the parties see that the stakes are so high that it's better to get a certain result through a settlement than it is to put it in the hands of the judge or potentially a jury if you've made it a jury case. But we talked some about the complaint. You serve the complaint on the defendant. Then typically within a couple of months after the complaint is in front of the court, then they'll have scheduling. You'll have to do some initial exchange of information, and then the biggest part in the case most of the time is the discovery part. And so this is when you're exchanging documents, when you're taking depositions, and if you're an inventor, most likely you're going to have your deposition taken in a patent infringement case. Then we have a claim construction part, which is when the court will be assessing essentially what the meaning is of certain terms that might be at dispute in the claims. Then we have, summary judgment, which doesn't happen in every case, but if one side or the other thinks that the other side doesn't have sufficient evidence to, like if you're the patent holder and you think, well, we've made a very clean case that there's infringement and they've not refuted that case, then you could ask for summary judgment, which would be that the court would find, as a matter of law that, there's infringement or, as to other issues. So it's intended to reduce or eliminate issues before you actually get to a trial. But, if there are still issues that are remaining, then you have the trial. And then after there's a judgment, you could have an appeal. So we'll talk just a little bit about, the specifics of that. So discovery, longest, costliest phase, you're going to have to produce documents. If there's software involved, there's almost always going to be source code review, to look at, how the accused product's working or, accused methods are working. You're going to have depositions of inventors, engineers, damages people. I mentioned before about, expert reports. You're generally going to have them on, infringement issues, invalidity issues, damages issues, and, inventors, if you're an inventor and your patent is at issue, you can almost guarantee that you're going to have your deposition taken because the other side's going to want to know what you think you came up with and try to narrow the issues that way. I mentioned claim construction. Sometimes you'll also refer to it as Markman. That was the court decision that established the claim construction process that we use in patent cases. And this is something that's done, before you get to trial, and it's the judge rather than a jury, interpreting the meaning and the scope of any claim terms that are at dispute. So, so if you have a term in your claims and, and there's a particular way that it needs to be defined for you to be able to show that a product infringes, then of course the infringer is going to want to try to come up with a definition that's still supported by your patent, but that may help them to avoid infringement. If you have a really broad definition of a claim term, then it might make your patent more open to invalidity attacks. And so this is a really important part of the case. Like you can't take it lightly, but it's generally done early enough in the case so that, the parties know how the terms are going to be defined before you do expert reports or really, get before a jury.
I'm sorry
Yeah.
to interrupt, but I
No, go
think
ahead.
we've run up against our time.
Oh, yeah,
It's about an hour. If you wouldn't mind wrapping things up quickly, that'd be great.
absolutely. And I'm happy to share my slides because I think I've covered
That's great.
all.
I can
I think
post them later.
Oh yeah, no, absolutely. So I think I've covered most of that. So I'm just gonna wrap up with the, with some of the, and we've talked about a lot of these already, but the, I think the key part is, you want to make sure that you do that due diligence before you ever consider filing a lawsuit, always understanding cost benefit, of it, asking the questions about what is this going to cost, how long is this going to take, and what are we likely to get out of it. That's really important. Ignoring, you're gonna probably have your patent challenged for validity reasons in almost every case, and so if you haven't really assessed the risk, then this may be something that sinks your case, and then your settlement, you can always try to settle at any point in time, and that can maximize your value. So taking away, these are, things, staying open to the settlement, knowing your exposure, knowing your timeline, your budget, and being able to, to make sure that you've done the due diligence beforehand. All of those things are key. So always happy to, take questions. You can reach out to me, any point in time, through my website, give me a call, anything like that. I'm always happy to talk with people. I'm not, like I said, I'm not the lawyer that, that's always encouraging people to get into patent litigation. I try to explore all the different avenues that we have to try to resolve the issues outside of litigation. But, if we have to get into that, then, then it's always good to know those, kind of the basics of how it works before you get too far into it. So,
I think we've got a hand here from Brian.
okay,
Brian,
of
you've got
course.
a question?
Yeah, I'm guessing this gets a little messy, but all your talk all your talk tonight has been about issued patents, and a patent that's been
Yep.
applied for, but may take a year, 2 years, whatever to issue.
hmm
But your sense is that it's going to be infringed. What can you just talk a little bit about that?
Sure. Yeah. So with, to actually file the lawsuit, you're going to need to have have an issued patent. It's not really, I mean, and I do get a lot of questions. I'm glad you brought that up because I get a lot of questions, particularly around that notice letter, thing, because they'll say, well, you know, I've got a patent application. I'm pretty confident that it's, in its current form, it's going to be, I mean, we still have to get it issued, but we think it's going to be infringed. Then a lot of times it's that idea of, oh, well, can I go and file a lawsuit, or can I go send that letter, telling somebody about that? And while you can, you're probably not going to get a lot of traction, especially if you're, if you're kind of prospectively, suggesting that somebody's going to be infringing it, because the response is typically going to be, well, but the patent office hasn't issued, they haven't fully examined your claims. You don't have an issued patent yet. So the claims could look a lot different than what you're asking me to license right now, or what you think is infringing. And so they'll probably say, come back later when you actually do have an issued patent. So that's typical, but I do feel like it's a good, as you're going through the process, there are times where I've seen, as we're trying to get a patent, we're already anticipating, well, if we do get this claim in this way, then these people would be infringing. And so it's, it can be a really helpful thing for you to be identifying those things as you're going through the examination process, because then if there's a way for you to modify your claims or broaden them to make sure that it's lining up with that accused product, then then you've got that opportunity to do it, as opposed to when it's issued and the claims are locked in, and then you're going to be stuck with whatever you got out of the examination. So it is a good thing. You shouldn't just close your eyes to what could potentially be infringing while you're going through the examination process, but your avenues for being able to really, license or enforce are limited, if any, until you actually get the issued patent.
And forgive me, because I'm sure you could spend hours talking about this, but the last thing would be, could you talk a little bit about international
Sure.
patenting?
No, that's very good question. So as many of you, if not all of you may know, I mean, what we've been talking about here is that, is the US system, and in every, I don't want to say every country, but, most countries have their own, patent systems, and then they have their own court systems that, that would govern the, a patent infringement claim. And so, but if you do get a US, if you get a US patent issued, then, your only avenue to, seek kind of seek any remedy for for infringement or trying to license would be as to things that are taking place in the US. And so if if you're thinking that your competitors or other potential users are going to be outside of the US, then you need to be thinking about that during the actual patent filing process, because you'd need, if you want to be able to sue somebody in Europe, for example, then you're going to need a European, you're going to need European patent protection. But the one area or kind of twist on it, and I mentioned this in passing, I think during the presentation, but it's important to mention again because I think it comes up a lot, is that your US patent will protect you or give you rights to stop people from importing from China, usually that's the, kind of the most common one. But, if you have someone that is making the product over in China and importing it into the US, then your US patent would protect you once it crosses the border into the US, to allow you to, sue for infringement or stop those activities from occurring. But if it's being made over in China and only sold in China and it never, crosses into the US, then you would need a Chinese patent and you would have to enforce in the Chinese courts, if you saw that there was infringement over there. So there is
Great. Thank you. Very
there is a
helpful,
way.
Kirby.
Yeah, I mean, because
Yeah,
I
thank
think
you.
people, quite often is because I will say, I mean, international patent protection admittedly is very expensive to get and expensive to maintain. Over time, much more expensive than I personally, I think than US patent protection is. And so, sometimes you have to make business decisions not to seek that protection in other parts of the world, but particularly if you are offering, if your patent is covering, um, hard goods, that would be imported into the US, then that is an angle that would allow you to, still have an option to, to license or to sue, based on activities that originated in another country.
Great. Thank you. Very helpful. I appreciate it.
Well,
Absolutely.
thank you, Kirby. That's been a terrific presentation. I hope everybody will join me in giving you a hand.
Thank you.
Great talk.
Appreciate it. And I'm happy. And I'll send you the slide deck
slides.
so
I
that
will
you
post
can.
them, and I'll post the video as well.
You're welcome to.
On the 21st of July, we'll be having Randy Landrenew, the president of US Inventor, doing a presentation. Randy has been pounding on me to try and get more politically active in railing against the American Invents Act and some of the articles that it contains, which include PTAB. Kirby and I had a discussion about this prior to the beginning of the meeting. I know a lot of people are riled about it, and I don't consider IACT to be a political group, but we're going to have a politically motivated individual who will give us the presentation. So if you're plugged into this and you want to hear about it, this is the person you want to listen to. That's July 21st at 5:30, same time, same Zoom channel. Thank you all very much for your attendance and attention, and I hope you have a nice evening.
Great.
Bye-bye.
Thanks for having me.
Thank you.
Okay. Have a good night.